A YouTube lawyer is getting his hands dirty. Now, this might come as a surprise to many of my viewers, but we YouTube lawyers, myself included, actually do put the gloves on and hop into the fighting ring quite often, especially this guy and this other guy. And now, Legal Eagle just showed that he sometimes does too, in a major way, by suing the federal government. Now, as you hopefully already know, I'm America's attorney. I've been a lawyer for over 23 years, helping over 20,000 clients. And today, we're going to be taking a look at this bad boy and talking to this bad boy. That's right. We're going to be talking to Kel McClanahan, co-counsel on Legal Eagle's lawsuit against the FBI and DOJ. Let's find out exactly what Legal Eagle is claiming, what he's asking for, and what I believe he's going to get. For those of you who don't know, Legal Eagle, aka the biggest legal YouTube channel in the entire known universe, has filed a lawsuit against the DOJ seeking the enforcement of an FOIA request tied to high-profile investigations into President-elect Donald Trump. Oh, what high-profile investigations, you ask? Well, crawl out from underneath that rock, Patrick Starr. I'm talking about the boxes of allegedly classified documents that Trump kept at Mar-a-Lago and his alleged role in allegedly attempting to overturn the results of the 2020 election. These events were under investigation by special counsel Jack Smith, seen here looking like a university president. But the investigations are apparently being wound down due to Trump's electoral win in November. A special counsel is a prosecutor appointed when there is a potential conflict of interest or a need for an independent investigation that might be compromised if handled by the regular Department of Justice or DOJ. This typically occurs in high-profile cases involving senior government officials, political sensitivities, or situations where the DOJ's impartiality could be questioned. The whole point is to have someone who is not in the chain of command beneath the big boss. The special counsel operates with significant independence. They have broader investigative powers and are not directly supervised by DOJ leadership, who, as you know, ultimately reports to the president, which allows them to pursue investigations without potential political interference. They can subpoena witnesses, conduct grand jury proceedings, and ultimately decide whether to file criminal charges based on their findings. Funding and authority are granted to allow a comprehensive arm's-length investigation that can thoroughly examine sensitive materials without the appearance of political manipulation or institutional bias. Did you hear that? Without the appearance of political manipulation. And yet, as soon as Trump won the 2024 election, announcements about the winding down of the investigations against him were made. So what is Legal Eagle claiming in this lawsuit filing? The DOJ has illegally denied his FOIA request to the Office of Information and Policy and to the FBI, and the DOJ has illegally denied the expedited processing of these requests. The lawsuit essentially states the same reasoning for each claim. Legal Eagle has a right under the FOIA to have its request fully processed, to be classified as a representative of the news media, and to receive a public interest fee waiver. And there is no legal basis for the denial by OIP of said rights. Each of the four causes of action gives details about the specific requests that were made and why they were made. But the general idea of the claims remains the same. The public is entitled to have access to this information. As a media source, the Legal Eagle YouTube channel is entitled to receive and disseminate this information, and the government is violating our rights by denying these requests. Let's take a look at Legal Eagle's request to be treated as a member of the media. My friends, the year is 2024. News comes from social media outlets all the time. Newspapers are dying or they're going online. Moreover, news is not just new information, but the thoughtful analysis of the meaning of the events that are discussed. I mean, hopefully thoughtful. You may not agree with Legal Eagle's take on politics and the news, but you cannot in good faith deny that he is a member of the media. The channel is probably second best place on YouTube to understand the intersection of law and current events. I can say he's second best, right? Even though his lawyer's about to be on the channel. The public interest fee waiver is straightforward. When you are going to further disseminate information that you get from an FOIA request, then the statute allows for a fee waiver. And since Legal Eagle is in the business of releasing videos, it's pretty straightforward to see he would further disseminate the information that he gets. He is definitely entitled to a waiver under the statute. So, why isn't his request for information being processed? And what's taking so long? Because ultimately, that's really what his case is about. And this question takes us to the part of the lawsuit filed by Legal Eagle called the prayer for relief, aka what he wants the court to grant him based on the lawsuit. And who better to help me dig into these issues than one of the lawyers who wrote that lawsuit? Let's ask Kel McClanahan some serious questions. Hey, Kel, thank you very much for coming into the studio. I am really glad to have you here. I want to know if you can just walk me through a little bit about the lawsuit, specifically, like what would be the end goal of this lawsuit?
It's better to start with what is not the end goal. It's what the government is going to say we want, which is, oh, everything that Jack Smith ever created and everybody on his team ever created, and oh my God, we just want the entire office. We don't want that, but we want a lot of it. We want everything that is not privileged, not classified, not the things that you would normally think should not be made public, that goes into the prosecution, goes into the report that he'll be writing, so that we can sort of release it and say, okay, you've read the report, hopefully. You've seen the indictment, you've seen the defenses made by former President Trump. Now look at the evidence for yourself. To coin a phrase, do your own research. You reach your own conclusions as to whether or not you think that this was a politically motivated witch hunt or a legitimate pursuit of someone who broke various laws.
Then it sounds like the goal, to paraphrase what you're saying, would be basically to get the entire investigation, at least that part that is releasable, to the public so that it just doesn't disappear into thin air.
That's part of it. And I will say that part of our goal, and a large part of our goal, is to make sure that they can't just destroy these records when they're done with them. Because that Ken Paxton, as Devin said, is going after these records. Some people in the House, some Republicans in the House, are going after these records. There is a very real fear that once they get their hands on them and cherry pick the part that makes their guy look good, they're going to just shred the rest. And they can't do that.
Or control the narrative by getting out a version early that's favorable to current power.
Yeah, that's what Bill Barr did. He summarized the Mueller report in a very misleading way. And then when it was ultimately released, it was bad enough that a federal judge even called DOJ to task for misrepresenting what it was about.
Can you offer any insight into why the current DOJ, meaning the Biden DOJ, right now, here we are in 2024, why that DOJ is apparently dragging its feet to give out the information that you've sought?
I'm going to give them a little bit of credit here. The FOIA request does admittedly ask for a lot of records, and it will be an undertaking for them to release it. Their reluctance to immediately get records out, they wouldn't be getting records immediately out if they had said, yes, we agree that this is the most expedited thing we've ever heard. That wouldn't mean we get records tomorrow. That would mean we would get records in a few months. And so the time period that has elapsed so far is kind of just built into the nobody funds FOIA offices, and they always have a huge backlog.
Well, what hurdles or arguments would you expect them to put in your place in the next, say, 60 days while this case kind of gets going?
Well, I'm already going to be moving to expedite the case, which is different than expediting the requests. Expediting the case is basically not saying to the judge that FBI and DOJ must process these records faster. It's you, Your Honor, should elevate this in your priority list of your cases. And so when we file a motion, you should rule on it instead of waiting a few months like is the norm for federal litigation. They've already indicated they're going to oppose that. Well, the second thing is the big argument that OIP is already making, the Office of Information Policy, which is, oh my God, there's so many records, we just couldn't possibly imagine what you're looking for. If we can get them to the mediation table, I'm sure that we will be able to work out a compromise. This has happened many times before. This is sort of the way you do FOIA, where you have to, as a requester, ask for everything. They say that's too much. And then you say, well, tell me what you have, and I'll sort of pick from those what I'm interested in.
Yeah.
Their position will be, well, no, we're just going to make you guess what we have and tell us what we want. And if you don't correctly guess that we have something, oh, no, I guess you did not request it. We don't have to process it. So that's the negotiating positions we're in right now.
But by filing a lawsuit in the District Court of DC, you've removed some of their authority and put it into the hands of what should be a neutral judge, right?
Well, we've removed their authority in that they can't unilaterally make a decision,
Yeah.
but they can still make a decision not to comply. They just have to then justify that decision to the judge.
Yeah.
And they would presumably exercise a little more caution before taking an extreme position. As Devin said in his video, Jason Leopold, a reporter, did this with BuzzFeed a few years ago for the entire Mueller investigation. And then once it was in litigation, they whittled it down to just a certain set of records. That's what we're looking to do.
Now, this is the type of case that doesn't typically have a trial, right? It's just decided on papers, or there might be a short evidentiary hearing.
There have been a handful of FOIA trials, but they're very rare. They're never jury trials. And for the most part, the lion's share, as you say, is written motion for summary judgment. I oppose it. They reply, and then the judge rules in it. They may have a motions hearing, and I've had those motions hearing be like little mini trials where we have to call witnesses, and I get to cross-examine the director of the FOIA office about something. So it can be almost a bench trial, but it never really quite gets to the bench trial stage.
Now, in his video, Legal Eagle points out that he already has a case pending against the government that's not completely dissimilar to this, and that one is still happening after a couple of years, or maybe more than a couple of years. How long is it possible for this case to get dragged out if that is the government's goal?
I am currently litigating a case that I filed in 2012.
Wow. Okay. That
It has gone through 6 motions.
Wow. Okay. All right. Well, so compare that to how long. I know this is a voluminous request, but compare that to how long this could or should take if the government weren't antagonistic to your request to air out these issues.
I think it's not unreasonable to think that this will take 3 or 4 years. There's a FOIA case that I'm in right now for Rolling Stone, where we asked for all the FBI's records on Henry Kissinger. And moving at the normal, non-extradited pace, they said that they would take about 3 years to produce records. Now, Henry Kissinger has been around for longer than I've been alive, and he has presumably a lot of stuff in his FBI files, because every time he did a deal or went abroad, they would write something about it. If the normal pace for someone like Kissinger is 3 years, then an expedited pace for something that's probably 10 times as many records would probably also be around 3 years. And so I think it's fair, at least for OIP. For FBI, they should be able to get it within a year, I would hope. But for OIP, I think that we would be resolving all of the records they were going to produce without us fighting over withholdings, probably within 3 or 4 years. That doesn't mean we wait 3 or 4 years and then we get records. We'll be getting like monthly releases of records.
Oh, wow. Okay.
So once they start processing things, we'll be getting them. Now, some of those may be this month we reviewed 1,000 pages and decided to give you none of them. So we'll be getting monthly responses, but not necessarily monthly releases. But they will be sort of trickling out the stuff.
Well, Kel, I really appreciate your time. I'm not dressed for court today. You clearly are. You need to get back into the courtroom and keep fighting for your clients. I hope we get to talk again soon sometime. Thanks a lot.
Thank you for having me.
And friends, these kinds of fights do take time. So while we wait on an update on the lawsuit, drop your pro se opinion down below. Do you think the American public has a right to the information revealed in Jack Smith's investigations? Are you cheering on Legal Eagle in his latest legal battle? Let me know what you think, and don't forget to lawyer up with me, America's Attorney, by hitting that subscribe button for more legal breakdowns. It's like an FOIA request. Every time that you hit the bell notification button, I'm here for you. I will see you soon. A special counsel. I look like I'm going to train a rooster for cockfighting or something.